case briefs, and so much more. LSData's got what you're looking for.
In the 1956 case Bedian v. Cohn, the Illinois Appellate Court addressed the question of whether a buyer could be held personally liable for a debt secured by a mortgage and note if the contract stated otherwise. The plaintiffs, Asador and Elizabeth Bedian, sued the defendant, Arnold Cohn, for personal liability over the remaining balance of a real estate purchase. While the mortgage and note stated that Cohn was not personally liable for any deficiency, an oral agreement between the parties indicated that Cohn would make a down payment and pay the balance in installments without personal liability. The court was asked to determine if the written agreement was valid or if the defendant was personally liable based on the oral agreement. The majority opinion held that the restriction on personal liability was valid, citing previous cases supporting the notion that a debt can exist even when there is no personal liability. The Illinois Appellate Court ultimately upheld the Chancellor's decision, finding the written agreement valid and Cohn not personally liable for the remaining balance. They noted that the seller had accepted the mortgage and note, acknowledging Cohn's non-liability, and deemed this provision valid and enforceable according to the agreement's terms.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.